see it.
Great. Thank you so much. And thanks everybody who's watching us live and who watches us after the fact for joining us here on this conversation about supported decision-making in New Jersey. I am Michael Brower. I'm the legal director at Disability Rights New Jersey. In just a second, my colleague, staff attorney Kelly McGuire will be joining me for our presentation. We really hope this is going to be something that's informative for you and really helpful if you're new to the idea of supported decision-making. If you're an old hand and you know all about supported decision-making, we hope that there's some information that you'll find helpful here too. We always try to grow and change our presentation, and it's a little bit new tonight. One just quick disclaimer before we get into anything further. Both Kelly and I are lawyers. We talk about legal concepts, we talk about laws here, but nothing here is legal advice. No attorney-client relationship should be inferred from anything we talk about here, even in the Q&A. So if you want any kind of legal advice, if you have a specific situation, you want to know what are your rights, what can you do, there is contact information that will come up at the very end of our presentation. If you wanted to request service assistance from Disability Rights New Jersey, you can. And of course, if you have your own attorney, you should always consult with them for legal advice. All right, the disclaimer's over. Let's get started. So this is us. We'll introduce ourselves individually in just a second, but I want to also introduce our organization, Disability Rights New Jersey. In case you haven't heard of us, we are a private nonprofit located here in Trenton, New Jersey. We are funded primarily with private donations, grants from the federal and state governments, and our mission is to advocate for the rights of individuals with disabilities across the state. On the screen is a picture of me wearing a blue suit and Kelly wearing a black jacket and green top. As New Jersey's designated protection and advocacy system, our mission is to preserve the human, civil, and legal rights of people with disabilities. We provide legal assistance to people with disabilities without charge in issue areas such as abuse or neglect, discrimination, voting rights, access to community services and supports, including Medicaid, employment services and vocational rehab services, and many other areas. In addition to our individual representation services, we also provide systemic advocacy on behalf of people with disabilities as a whole. We have a very unique authority as a protection and advocacy system to both monitor for and investigate abuse and neglect in any type of program or facility that serves people with disabilities. So we're not just a regular law firm. We do that investigation and monitoring aspect as well. We provide legal services, like I said, in a variety of areas. If you're interested in learning a little bit more about that, I would encourage you to visit our website where we've just posted our new goals and objectives for the coming 3 years. That's disabilityrightsnj.org. That will go up on the screen at the end of the presentation. And again, I would really encourage you to take a look because we've done a lot of work and we think it's pretty exciting, some of the most high priority issues that we're working on. Just for myself, I've been with the agency since 2016. I serve currently as a legal director. Before that, I worked as a managing attorney of our community inclusion team. And before that, I was a staff attorney, working primarily for clients with developmental disabilities, but also working with individuals who lived in psychiatric hospitals, nursing homes, and our state's developmental centers. So I've worked with all different kinds of populations in my time here, and across all of them, I found that this issue, decision-making, has been extremely relevant for every single one. So with that, Kelly, I'll turn it over to you to introduce yourself.
Good evening. My name is Kelly McGuire, and I'm a staff attorney on the community inclusion team at Disability Rights New Jersey. I've been at Disability Rights New Jersey since January of this year, so almost a year. And I actually started at the agency as an intern while I was in law school in 2017. So that's a bit of background into my role in the agency. I do a lot of representation of clients that are based in the community, including with supported decision-making and guardianship issues.
Okay, so I want to give, now that we've gotten ourselves introduced, I want to do a little bit of road mapping. And Kelly, I guess here I'll hand it to you to take it away from the roadmap page.
Sure. Today we're going to talk about supported decision making. So this will necessarily require that we compare and contrast supported decision making with the framework of guardianship in New Jersey. So we will be comparing those two concepts and talking about how they work in the larger scheme of decision making that we all use every day. And we're also going to discuss powers of attorney, which can serve as a less restrictive alternative to guardianship, as well as some other alternative documentation. So by the end of this presentation, you should be able to define supported decision-making, differentiate it from guardianship, and identify at least two ways that you can help promote self-determination. That brings us to the next slide. Regardless of whether you have a disability or not, I want to start with a conversation about supported decision making. So let's do a little thought exercise. Everybody makes decisions all the time, and regardless of whether you consider yourself to have a disability, it's probably pretty rare that you actually make a decision completely independently. Those decisions can range from pretty insignificant decisions like what color shirt should I wear today, and go all the way up to very serious, what kind of medical care do I want if I become gravely ill? So I want to start with something in the middle and work our way through the process to help lay the groundwork for our discussion this evening. So let's pick a common experience that we probably all share. And since we are located in New Jersey, hopefully we have all either driven a car or been a passenger in a car. On the screen in front of you, you can see two images. On the left is a man looking in despair at the hood of his car, and on the right is a very happy mechanic giving you a thumbs up. The scenario is as follows. Your car stalls on the highway while you're on a road trip. You're far away from home, you don't know what happened to your car, but all of a sudden your car is losing power and slowing down. You don't have a lot of time to handle this situation before it gets dangerous. So what do? Maybe you decide to pull over, put on your flashers, and call a tow truck. But how do you know whether or not to do those things? Did you learn those in a classroom? Do you have experience as a driver or as a passenger in a vehicle that breaks down? And if you don't have training or experience, would you naturally know what to do when your car loses power? After you pull over, the tow truck brings you to a mechanic. And then how do you decide what to do? You talk to the mechanic and get an estimate for the repairs, or start thinking about whether the car is even worth fixing. Can you make a good decision about those things as soon as you arrive? You probably will need more information than you initially have. Maybe you let the mechanic take a look at the car and they come back with a diagnosis and an estimate for the cost of repairs. But what if the mechanic starts throwing out words like spark coils and carburetors and clutch cylinders, and you have no idea what any of those things are? Maybe what happened was that you just ran out of gas and all you need is to put some more fuel in your car. Or maybe you blew a head gasket and the mechanic wants thousands of dollars to do repairs. Even after you hear from the mechanic about what they think is wrong with the car, how do you decide what you're going to do? Do you think you might call your sibling who has a lot of experience fixing cars as a hobby, or the mechanic that you usually take your car to back in your hometown? Maybe you need to know how far away you are from your destination and what will happen if you're late where you're going. Maybe you need to know if there's rental cars available nearby. And before you get all of the information that you need, are you competent to decide what to do? And who ultimately is responsible to decide what to do? If the mechanic makes a recommendation and you agree, does the mechanic decide that they're going to fix your car? Of course not. The decision is yours, whether you want to make the repairs to the car or not. Next slide. Maybe all of the decisions that are available to you are too overwhelming and you don't make any of them. You're in this situation, you're speeding down the highway, your car is rapidly losing power, and you just don't make a decision. Your car slowly coasts into a ditch, you get out, and in front of your screen now is a picture of a car in a ditch, rusting with some tall weeds, which is likely to happen if you choose to make no decision. But deciding not to decide is still an exercise in decision making. There's no escape from decision making. Whatever you do, whether you pull over, go to the mechanic, call a tow truck, or make no decision, you have made a decision. No matter how that situation with your car came out, you probably used some form of supported decision making to respond to an unexpected problem. You got the information, explanation, and help communicating from the mechanic or your sibling or your coworker who calmed you down and promised to cover a business meeting that you were going to miss. If you've never had a car break down on you or you've never dealt with a mechanic, it might have been a very stressful situation. Even if you drive a 6-year-old car and this happens to you all the time, you still might have needed some or all of the same supports. The same kinds of decisions come up all the time, and people typically seek out support for making them. People ask questions to their doctors before a medical procedure or get a second opinion. We talk to our friends or even strangers on Facebook when we're trying to figure out where to rent an apartment in a new neighborhood. Maybe you talk with your family about your major career moves, and you call on people that you know will handle a situation calmly when you have to deal with something stressful. Sometimes, even with help, people make mistakes or decide on a course of action without fully understanding all of the risks. Maybe you rent an apartment in a very nice part of town, but it happens to be right near a noisy train line. Or maybe you decide to get a tattoo, which seemed like a great idea at the time, and then you break up with your ex another year later. Think about all the wealthy people that were surrounded by experienced financial advisors that invested money with Bernie Madoff because they didn't understand what they were getting into. Even with all the support in the world, people make mistakes, but we're all allowed to make those mistakes and learn from them. Next slide. So in all of these situations, from the stalled engine to Bernie Madoff, we're assuming that the person in charge of the decision-making is you. You told the mechanic to fix the engine. You considered the advice and input that you received on any of those decisions. You listened to some, you rejected some, and you decided what to do. That's all supported decision-making. Not every decision is supported. Some people might not seek any advice on small or large decisions and decide only what's already inside your brain. The shirt example is a good one. You look in your closet and you grab a shirt out without consulting anyone. Typically, the more consequence comes with the decision, the more we seek out support. Up on the screen is an arrow pointing from left to right with 4 colored dots. The first 3 dots from left to right are gray and labeled independent, supported, and surrogate. The last dot is blue and labeled substitute. We'll refer back to this arrow later. If you look at decision-making from the perspective of who is the decider, you'll start to see that things line up in a spectrum. The more input that we have from other people, the further away we have moved from independent decision-making. And we've talked a little bit about independent decision-making and supported decision-making. In both of these, you are the ultimate decider. The next dot is surrogate decision-making, which is where someone else decides for you, but they make that decision based on your values and your documented wishes. Sometimes you might be able to overrule them in the decision-making process, but not always. Essentially, this is like somebody standing in for you as a surrogate. And we'll talk a little bit more about that when we get to powers of attorney. On the last dot, we have substitute decision-making. In this context, a substitute decision maker makes decisions for you based on what they think is good for you. They might apply objective standards like a best interest test, or they might consider your wishes. In all situations, however, the substitute decision maker is the one making the decision, not you. In the broken down car scenario, this is like if you called your brother to help you decide what to do in the breakdown situation, and he takes the phone from the mechanic and makes the decisions from there. In this substitute decision-making scheme, you are a passenger in the decision-making process, no longer in the driver's seat. A full guardianship is the most common example of a substitute decision maker. And this is why we consider those full guardianships to be the most restrictive decision-making mechanism, since you no longer have control over the decisions in your life. Next slide. Decision-making isn't all that different for people with cognitive disabilities, whether that disability is developmental, psychiatric, or as a result of a brain injury. The difference might be how far into routine decisions you need support, or how heavily you rely on that support to make those decisions. Supported decision-making can be informal, where supporters get involved only when you ask, or it can be more formal with a written document of who is involved, a regular meeting schedule, and designation on who's going to help you with what decisions. On the screen in front of you is a picture of former President Barack Obama seated at a conference table surrounded by advisors in the White House. Believe it or not, this is an example of formal supported decision-making, even though President Obama did not have a disability. All of these people were formally appointed to help him gather information and make decisions and communicate those decisions, even though ultimately it's President Obama making the decisions. So formal supports can come from anywhere. Family and friends could be part of that formal arrangement, and so could professional staff. So the president here is selecting diplomats and speechwriters and treasury secretaries, while you might be selecting caregivers and doctors and accountants, clergy, lawyers, and social workers that will help you make decisions. How formal that agreement is up to you. There's a bunch of really good sample supported decision-making agreements available at supporteddecisionmaking.org. These forms are meant to help you document and clarify the role of your supporters in an arrangement so everybody knows what their job is, and you can reference that document when needed. I would also caution you to beware of someone claiming to be a supported decision maker for you. So if you think back to the continuum of decision making we saw in the last slide, supported decision-making revolves around maintaining self-determination so that nobody has the authority to decide except for you. Even if your sibling is recommending repairing the car, you are ultimately deciding whether to do it. Everyone else is going to support you in making a decision or support you in communicating that decision. If someone in your supported decision-making agreement starts to make decisions for you, we're starting to slide towards surrogate or supported substitute decision-making on that decision-making continuum. You're muted, Michael.
That was a wonderful overview of supported decision-making, and thank you for catching that for me. I think that's a good way to start thinking about the fact that supported decision-making happens for everybody, regardless of whether or not you're a person with a disability. So I want to take that, though, and I want to shift into guardianship to do a little bit of comparison and contrasting with the supported decision-making scheme, and to see maybe where there's places those two things might overlap. And so I want to talk a little bit about guardianship and where it comes from. I think it's important. I have a formal training in history as an undergraduate, and so to me, the story of where things come from helps tell us where we are today. And for guardianship, it comes from medieval England, where the king or the queen was the figurative parent of all the subjects of the land. And those people could be seen almost like children, even if they were grown adults. And like any parent, the king or the queen had a duty to protect them if they couldn't protect themselves. And so under the laws of England, if the king or the queen decided that somebody was either an orphaned child or maybe they were an adult with a disability and they were worried, especially if that person held lots of land, the king or the queen might step in and exercise the parental power of the state on behalf of the crown and take whatever action they needed to take. Taking over control of land, making decisions about what crops to plant or what to sell or what to buy, what to rent. That same concept that came from medieval England across the ocean to the American colonies and has evolved here in the United States over the years since independence. You can see the modern forms of that power of the king or the queen in forms of things like child protective services, right? Children without adults or responsible adults to care for them, the state may step in and provide care themselves. And for adults, that mostly comes in the form of guardianship. So remember that this history tells us that the state is the power holder here. So when we talk about somebody being appointed as a guardian later on, it's just that. The state, acting through the courts, appoints a guardian. And that guardian makes decisions for the person on behalf of the state. Ultimately, the court retains the power. They keep the authority to decide any particular decision, to replace who's serving as the guardian, or even to make decisions themselves if they think it's necessary, or to stop the guardianship, to make a decision that somebody doesn't need one anymore. Guardianship generally is going to fall all the way on the right hand, that blue dot on the spectrum that Kelly described earlier, because this is where the guardian is substituting their judgment, or the court is substituting their judgment to make decisions for somebody, with a few important limitations that we'll talk about. I just want to read the standard that New Jersey applies to decide if somebody needs a guardian or not, because not everybody needs a guardian, and not everybody with a disability needs a guardian, even in the eyes of the court. The standard that gets applied comes from the statute, and the citation's up on the screen. If you want to go look it up, you can read this yourself. But a standard is that somebody is determined to need a guardian if they have incapacity. And somebody with incapacity is an individual, quote, who is impaired by reason of mental illness or intellectual disability to the extent that the individual lacks sufficient capacity to govern himself and manage his affairs. So the court finds that somebody needs a guardian only after they've decided that they can't govern themselves or manage their affairs. I want to talk a little about what a guardianship is not, because sometimes that's a great way to help us understand what something is. First off, guardianship does not create absolute control or the removal of all rights for somebody who is found to be incapacitated by the courts. Even somebody who has a general guardianship, and this is commonly misunderstood in New Jersey, but even for somebody where the court says somebody lacks all capacity in all the areas of decision making, that individual still retains some very important rights, and in fact, they retain many rights that are commonly overlooked. There's a Supreme Court case called In Re MR, and MR was an individual with intellectual disabilities who the court had already found, because they had Down syndrome, needed a general guardian, that they needed a person to make most decisions for them. MR had an opinion about where they wanted to live, and there was a dispute with their guardian about how that was going to go. So this case went through the court system and ended up all the way in front of the New Jersey Supreme Court, who ultimately said, and I'm going to quote a few things here from the opinion because I think they're really powerful words. The Supreme Court said that we are reminded that the mere fact that a person is generally incompetent does not mean that the person is incompetent for all purposes. They can still make choices about specific matters. The court went on to say that they recognized that as a decision increases in importance, so should the right of the affected person to make that decision. And the court's goal was to permit developmentally disabled people to make as many decisions as possible while protecting them from the harmful effect of bad decisions that they do not fully understand. The real takeaway that the court came with, and this is the most powerful thing for lawyers, but for advocates and people in this world, it makes sense to answer the question, is there absolute control? And the answer can pretty squarely be said, no, there is not. Because the court said that somebody who's challenging MR's decision about where she lived was going to bear the burden of proving that MR couldn't make that decision herself. So this is somebody we're talking about who already has gone through the guardianship process, where the court has said they need a guardian. They have no capacity. They can't manage or govern their own affairs. But even though that finding has already been made, MR still gets to decide where she lives, and the guardian has to listen, unless the guardian can come to court and prove that MR does not understand that decision. That's a very powerful ruling from our Supreme Court, and it's not new. This is from 1994. It's almost 20 years old now, the decision from MR. Guardianship is also not all-seeing or all-knowing. Somebody who has a guardian doesn't wear a sandwich board around, a little sign pinned that says, I have a guardian. The guardian doesn't follow them around everywhere that they go. So part of having a guardianship is not getting a live look in every moment and knowing everything that goes on. Again, it's a common misconception that guardians, again, have this kind of absolute power. And there's something I wanted to mention that on that absolute power, go back one step, is that guardians have a requirement to engage the person that they are the guardian for with decision making, to understand what their preferences are, to give regard to those preferences, and really to encourage the person they work for to participate in this decision making process to the maximum extent of their ability, and to develop or regain higher capacity in places where they don't have it. And by court rule, someone with a guardian always has the right to go back to court and to challenge the decision making of the guardian. So if there's a disagreement, remember the Supreme Court says the individual with the disability decides first, and only if we prove that they don't understand the decision does the guardian get to overrule them. So if there's a disagreement between the guardian and the person with the guardian always gets to go back into court and ask the judge to review that decision. So there's a lot of places where somebody, even with a general guardian, still gets to decide for themselves. Guardianship is not a magic wand. So if a person with a guardianship signs a lease for a car or opens a cell phone plan or shoplifts from a grocery store, right, makes a pretty big mistake, there's still going to be implications for those actions. Just because somebody has a guardian doesn't mean they're inside a magical protective bubble. And the fact that they have a guardian is not going to remove the consequences for those actions. For that car payment, there's still going to be a bill due at the end of the month, and there's going to have to be something resolved if the person doesn't pay or if nobody pays. If the cell phone bill goes to collections and ultimately ends up in a small claims case against the individual, somebody's going to have to defend that lawsuit and explain to a judge why the individual shouldn't have to pay. And having a guardian is not going to be an automatic win. Somebody who shoplifts, even if they have a guardian, they're still likely to be arrested for theft and have to face some kind of municipal charges about that. In any of those situations, the guardian would have to still take some kind of action, prove if they wanted to try that the individual lacked capacity and see if that was going to undo those consequences. But trust me, as recently as this week, we've talked to individuals, people with guardians in New Jersey, who are facing serious criminal punishment for actions directly related to their disability. Guardianship is not stopping those criminal actions from going forward. Those people still have to defend themselves in court. Guardianship, as I mentioned, is also not tied to the guardian, but it's about whether or not somebody lacks capacity, and it's about the court exercising the power of the state. So that means the guardianship is not yours to control if you're the guardian. If the guardian passes away or becomes unavailable or themselves becomes disabled, the court finding that somebody lacks capacity, needs a guardian, is still going to be there. And the court's going to need to replace that guardian with somebody else. For parents who seek guardianship of their children when they turn 18 years old, oftentimes this comes as a surprise. They think, oh, well, I'll just be guardian. And when I pass away, they'll be old enough, they'll take over. It's not how it works. That guardianship order will stay. And the individual may end up with, if there's no family or relatives, a state agency acting as their guardian, or an attorney who's a total stranger because they're familiar to the court's roster, may be appointed as a replacement. And again, these are particularly, almost universally going to be strangers for the person with a guardian. And finally, I guess on the same note, it's important to know that guardianship is not temporary. It is not easy to undo. It takes a court to find incapacity. They have to go through a hearing process. A judge has to sign the order that says somebody needs a guardian. And because of that, it takes a court order to restore capacity, to say that somebody no longer needs a guardian. It can't be done because just everybody agrees, even if the guardian is on the same page as the person, as the same page as all their doctors and their treatment providers and their social workers. That doesn't make a difference. It is the judiciary that ultimately holds the power to turn off a guardianship if they think it's no longer necessary. But I think Kelly and I can tell you from our experiences that judges in New Jersey, even though they are diverse and they're not one body, generally are very hesitant to restore somebody to capacity. They're only going to do it when it's extremely clear. And even if the guardian is asking for it, the judge may put the parties through a legal ringer to get to a decision to restore capacity. If there's a conflict, if the guardian thinks somebody still needs one and the individual wants to fight it, that's going to be a large legal battle. I've seen it cost tens of and hundreds of thousands of dollars in legal fees to get somebody restored to capacity if there's any kind of a dispute. But without a court order, someone found to be incapacitated will maintain that status. They will need a guardian in the eyes of the state until they die or until a court order says otherwise. So it's important to know what a guardianship is not. So if we kind of take all of those, what is a guardianship, and we take that and we start contrasting it with what is supported decision making, I have up on the screen a Venn diagram. The big bubble is supported decision making, and the little bubble that overlaps is guardianship. Most of us, pretty much everybody, fall somewhere in the big bubble that we use supported decision making. If you're somebody who is maybe totally unable to communicate your preferences, no expressive language, even if you had help and support and technology, and you couldn't express a preference of any kind, you might fall in this slice of the guardianship bubble outside of supported decision making, because you may not be able to express a preference on any kind of decision. And there are a few people that are in the world with that kind of disability. But for the most part, people who are in the DD system fall in this part of the guardianship bubble, where the law requires them to participate in the decision-making process. And even if your guardian disagrees with you and you felt strongly, people in this part of the bubble, even with a guardian, have a right to participate in decision-making and go to court. And the guardian will have to bear the burden of proving why you might not be able to have an opinion in a matter. That's going to be a tall order for them to win. So we have supported decision-making even in the context of guardianship. It's a little thought about world when you start to think about what guardianship really is and what supported decision-making really is, that you see that there's this big overlap. Right? This is supported decision-making, giving due regard, listening to preferences. Um, you know, these are all questions that start to tell us we need to think about supported decision-making even for people with guardians. But we might also think of supported decision-making as a less restrictive alternative to somebody who maybe needs a guardian. Maybe there's a less restrictive way, not stripping them of their legal rights, that we can provide support and help them make decisions and go through that process. Hand the microphone back to Kelly.
Thank you, Michael. So hopefully I've given you a definition of supported decision-making that you understand, and hopefully Michael has explained to you the differences between supported decision-making and guardianship. So now for the rest of our conversation, I want to talk about what you can actually do starting right now to promote self-determination for yourself or for your family members. Next slide. If you're in this session today, it's probably because you're at least a little bit interested in learning more about supported decision-making. So we've talked about how most of us, regardless of our disability status, use some form of supported decision-making to navigate our day-to-day decisions. For people with disabilities, having the right to decide can sometimes come into question by third parties. So having a documented, formal supported decision-making agreement can help overcome some of those stigmas and obstacles. And you can craft your supported decision-making agreement however works for you. It's a very flexible arrangement, and it can include what you want, and it can include who you want. That being said, there are a few fundamental elements that you should consider including if you draft a supported decision-making agreement. And since we are lawyers, we like those things to be memorialized in writing. So on your screen are 4 things that we recommend including in a supported decision-making agreement. First, who is ultimately going to be responsible to decide? Define that and put it in writing clearly. And if you've been listening to our conversation on that spectrum of decision-making, you know that the decider in this agreement is the individual themselves. They are in the driver's seat and they retain the decision-making authority, but it's helpful to put that in writing in the agreement to remind everybody involved that what that individual says goes. The decider should also have the power to change the decision-making agreement at any time for any reason, including removing and replacing different supporters. And this is an advantage that supported decision-making offers over guardianship, where the individual subject to guardianship doesn't necessarily have the authority to choose their guardian or to change their guardian. But in a supported decision-making agreement, which is not regulated directly by the courts, they can change and replace those supporters as needed. Which brings us to the second point, the supporters themselves. That's the next thing you need to define in your supported decision-making agreement. It helps to be specific for each supporter for the ways in which they are involved to help the decider come to a decision. And that role can be different for each supporter, and they can be involved in different categories of decision-making. For some people, your supporter system might only be 1 or 2 people, your mom and dad, or your brother and your sister, or just one of those people. Other people might have a big network of friends and family, professional supports, even those who are paid, like accountants and lawyers and support staff that you want to include as supporters in your supported decision-making agreement. Everyone that's identified as a supporter in the agreement should be aware of what their role is, and the role should be written down. Is that person responsible for gathering information or breaking down complicated information into understandable chunks? Is the person responsible for giving their input and their advice on what course of action to take? It would also help if each of those supporters signs off on the document acknowledging that they understand what their role is and what they will be asked to do. The next step is to define the process. Is there going to be regular meetings between the decider and his supporters, or between the supporters? Will there be one supporter responsible for summoning all of the others when needed? Will the decider be picking up the phone and calling each supporter individually, or calling a meeting of all of the supporters when they need help? How will the decider communicate with their supporters? And will any of the supporters have responsibility to keep tabs to make sure that none of the other supporters are overstepping their role? And how will the decider or the supporters know when the decider has made a decision and the conversation is over? And the final step is the communicator. Who will communicate, if anyone, on behalf of the decider? If part of the person's disability is a communication impairment, are they going to use a trusted interpreter to communicate their decisions? Do they have a communications board or some assistive technology that they can use? How will the outside world know that what's communicated is what the decider actually wishes to occur? This can be a tricky part of the process, and it should be carefully tailored to maximize oversight from the decider themselves and from other supporters to make sure that the communicator is not injecting their own judgment into the message, but is in fact communicating what the decider wants. And again, I have the link on that slide for examples of supported decision-making agreements at supporteddecisionmaking.org. So practice makes perfect, and we're talking about practice here. Even if you never have the opportunity to make mistakes, make decisions, learn from your mistakes, and try again, you'll never learn how to make decisions. Many parents of people with disabilities have been battling since they were a child to ensure that they get services, to fight discrimination, to protect their children from any troubles that might encounter them in life. So there's not really a clear line between that essential parenting and the transition to adulthood. If the transition doesn't happen and a parent makes every single decision until an individual turns 18, you end up with an 18-year-old who has no practical decision-making experience. And no doubt, somebody who has never been involved in determining their own outcomes will probably not be very good at it when they're thrown into the deep end and they turn 18 as a teenager. Like our car example back in the beginning, you'll be better equipped to ask for the right kind of help, ask the right questions, and determine a course of action if you have been through that experience before, and if you know how to call for the right kind of help. Even if you've just done something as an observer, seen your parents encounter a crisis or make a decision, that will help you learn how to do it when you are in the driver's seat doing it for yourself. So when the stakes are low and your child is under 18, the law gives parents decision-making authority by default. And this is when you really should start to have the conversation about how to make decisions. It's never too early to have that conversation. You can start at a very young age and just keep practicing how to make decisions and how to get better at it. Involve your children in the decision-making process, ask them to participate. Explain how you're going to make calls on big decisions and even small decisions. Beyond disability-related services, involve children in paying bills, balancing checkbooks, writing your shopping lists, and even something as simple as getting dressed. Those things can all pay dividends later on when it comes time for your child to make their own decisions on their own. As much as possible, give children room to make decisions, which includes the space to make mistakes. The goal of these activities is to learn and to grow and to get practice for adulthood, and make that clear to your children while they're learning this decision-making process. Make sure that they know that it's okay to make mistakes. And when that happens, you should have a conversation about what went wrong, what went right, and what should happen next time to make a better decision. Obviously, you need to tailor these conversations and goals to the age and developmental status of your child. If you think that a supported decision-making agreement is going to be in your future, start those conversations very early. Identify and draft those supporters that are going to participate in these conversations during childhood so the same people can stay seamlessly involved into adulthood. But note that despite the fact that it can never be too early to start learning how to make decisions, it is also never too late. Even for adults with guardians, the same principles apply. Remember, as Michael explained, that guardians have a legal obligation to help the individuals subject to guardianship develop decision-making skills and to involve that individual in those decisions as much as possible. If the guardian makes all of the decisions without involving the individual, it's hard to know how they would learn the skills to manage their own affairs. So if you keep practicing the decision making, even with a guardian in place or before a guardian becomes in place at age 18, if you've made every decision for your child up until they turn 18, it's not too late for them to learn, develop, and build that capacity in adulthood. Next slide. So as I mentioned, supported decision-making agreements are completely customizable. You can tailor your agreement to support your needs. Many parents are very concerned about providing financial protection for their children after they turn 18. On the screen in front of you is an excerpt from a Delaware supported decision-making agreement. Specifically excerpted here is the financial affairs section of that particular supported decision-making agreement. And as you can see, it is pretty customizable, and there's a lot you can do with this. So with supported decision-making, you can choose the right people to provide the right help at the right time. Maybe this will include regular budget meetings on the day before your paycheck comes in, or the day before the big bills are due. Maybe your supported decision-making agreement includes a power of attorney that can access and review your finances for signs of fraud. Maybe you want to include credit locks or freezes in your supported decision-making agreement. Maybe you want to add a cosigner to your bank account or establish a trust. Compare this with guardianship, where the guardian does not have any specific controls. To be effective, the guardian would need to do something that looks just like supported decision-making. Determine the individual's goals and their desires and their preferences, and make the decisions that effectuate that. Guardianship still requires the use of supported decision-making, but it takes away the individual's self-determination by removing the individual themselves from the driver's seat. Next slide. So there are other related legal tools that can serve as less restrictive alternatives to guardianship. And on your screen, there are three such tools that are related to supported decision-making and can be used to supplement or formalize as decision-making support that someone might want to give to a trusted decider. Note that these depart from the classic model of retaining decision-making authority for oneself. The first one on the left is a power of attorney. And this is a broad, or it can be a specific assignment of authority to an agent. Now, this is a voluntary and concurrent power, which means that the agent has authority to make some decisions, has some power, but the individual themselves also retains that power. Now, powers of attorney in New Jersey cannot cover healthcare decisions, which brings us to the middle sample you see on this slide, which is healthcare proxy. And these are specific to healthcare decisions. This only becomes operative if the person loses capacity to decide or to communicate their decisions. This can outline what your general wishes are for your healthcare and appoint a trusted person to make those decisions until your capacity is restored or your life ends. And the third document here is a psychiatric advance directive. This becomes operative based on conditions that are set by the person who drafts this for themselves, whether that is incapacity or particular signs or symptoms of a mental health crisis. This document will direct healthcare providers on the individual's wishes for medications and treatments, and it can appoint a proxy in the event of a psychiatric crisis. And important to note is that this document can be overridden if there is a danger to yourself or others that requires different levels of treatment. Michael, did you have anything to add on either of those? Any of those?
Yeah, I would just chime in that if anyone is looking to create a power of attorney, a healthcare proxy, or a psychiatric advance directive, we can point them to our website. We have presentations that Disability Rights New Jersey has done in collaboration with the Mental Health Association on especially psychiatric advance directives. People haven't heard of those. They're a little bit more complex. But healthcare proxy, the form is available from the Jersey Department of Health. There's a standardized forms. The power of attorney is the most complex of these three. And I would just say to people, if you're looking to draft a power of attorney, you really, really, really want to consult with an attorney in the state who's familiar with these things, because the language really matters. And so all these are good ones to seek the advice of counsel, but especially if you're looking to draft a power of attorney, the second two can be done a little bit more self-help. But all of them generally recognized, enabled by statute in the state here, and will be pretty effective at helping people make decisions in situations where maybe they're not able to make the decisions or to be present to make those decisions for themselves. This is surrogate decision making on our spectrum. But other than that, I think we covered all the bases in terms of the alternatives that we have. I just wanted to put up our contact information here. Our website, again, is disabilityrightsinj.org. Your social media, if you're a social media person, our general inquiry email address, the 800 number, the regular number, mailing address, all here. If anyone wanted to reach out and get in touch with us. And if you're just curious, what does Disability Rights New Jersey do generally beyond talking about guardianship and supported decision-making, visit the website and you can peruse our new set of goals and objectives that are covering us for the next 3 years. And with that, just want to check to see, I know we've got a pretty small audience today, but if there's any questions or answers, we've got a few minutes.
Thank you, Michael. Thank you, Kelly. Any questions we can answer this evening? Please don't hesitate to come off mute or place them in the chat. All right. Thank you. Yes, amazing presentation. Agreed wholeheartedly.
Thank you,
Michael,
Jamie.
wonderful knowledge. That does conclude the workshop this evening on supported decision-making made practical. My name is Kathleen Chikara from Public Partnerships PPL, and hosting on behalf of the Self-Direction Conference Planning Committee. I would like to thank Michael and Kelly for their time this evening and also sharing their in-depth knowledge and resources with us today. With that, we will close our presentation.
Thank you so much.